Hey there, everybody. So we are actually into the last chapter for our textbook. This is actually chapter 13. And chapter 13 really gets into the legal guidelines for group fitness instructors and some of the professional responsibilities that we need to pay attention to. So the legal aspect is something that is also important in addition to understanding how to effectively lead group exercise. So while we're a newly certified group fitness instructor has definitely proven that they have the ability to apply broad-based knowledge to various subjects in a variety of practical situations. This credential should definitely be viewed as the foundation of professional development. So ongoing education and training are both necessary and they're both required, as is a thorough understanding of our professional boundaries and scope of practice in order to protect and best serve our participants. So as far as continuing education, maybe it's focusing on a special modality or a special participant demographic. So finding out what your niche is. What is it that you're going to specialize in? Maybe it's a older adult population, maybe it's the youth, maybe it's the athlete. But continuing your education in these particular areas that you're really truly interested in is going to help to establish you as an expert in that area. So when you're going to continue your education and get your continuing education credits so you can get your recertification again, then you want to take workshops and different types of courses that deal with that particular topic or that particular population that you're really interested in. So best practices for staying current on research and guidelines is to definitely review credible resources that are out there in the industry and a variety of them. So obviously ACE, fitness.org is definitely a very credible resource. ACSM, NSCA, American Heart Association, those types of websites and businesses are definitely all credible types of places to look for information. Not, magazines like Muscle and Fitness, things like that. Resources aren't very credible. So you have to be careful about where you're gathering your information from. And then referrals and developing a referral network. We want to identify those health professionals in our area that are reputable, right? And if we do need to refer our clients to a particular health professional, we are referring them to reputable individuals. So as far as that legal framework goes, with that continued evolution of the health and fitness industry, group fitness instructors must develop and maintain an understanding of basic legal concepts that apply to the field in which they practice. So from the employment status and copyright law to insurance coverage, risk management, learning how these concepts apply to the group fitness setting will help to minimize the risk of injury to our participants. It will also decrease the risk of potential litigation and mitigate potential damages. Group fitness instructors should also have a thorough understanding of the concept of standard of care, liability, and negligence in their field. So what do these terms mean? Liability, those are responsibilities recognized by a court of law. If we do something that causes our client or our participant in our class to become injured, we could be held liable for their injuries in a court of law. And then standard of care is the responsibilities arising from the relationship between the group fitness instructor and the participant that produce a legal expectation. So being a certified group fitness instructor, we have to uphold a certain standard of care when we're working with those participants in our classes. So again, just looking at negligence and what does that term mean? It simply is the failure to act as a reasonable and prudent person would act under a similar circumstance. So we can be held negligent really by doing two different things. One is by acts of omission and as well as acts of commission. So the difference between that is an act of omission is the failure to act. Okay, so we omitted, we failed to tell them to do something that would have caused them to perform the movement appropriately. So maybe I failed to tell my client to, when they step up on the step during step aerobics, to get their entire foot up on top of the step. And I failed to do that, and so my client maybe didn't step all the way up. They tripped on the step, they went face first down on the floor and became injured. I forgot to tell them an important cue as far as how to perform the movement appropriately. Whereas acts of commission, I tell them to do something that actually led to the injury. Maybe I tell them to do a move that's contraindicated or that's not safe. And by me telling them to perform the move that way, that led directly to their injury. So omission, neglecting to tell them something that should have been told, and commission, telling them to do something that should not have been done. So there are 4 legal elements that in a court of law a judge is going to take a look at. So first of all, they're going to decide, did the defendant have a duty to protect the plaintiff from injury? Who is the defendant? The defendant is the person being sued. The plaintiff is the person filing the suit. So did that defendant, that would be the group fitness instructor in this case, have a duty to protect the class participant from injury? And in most cases, yes, we do have that duty when they enter into our classes. Number 2, the judge is going to decide, did the defendant fail to exercise the standard of care necessary to perform that duty? So what is the standard of care for a group fitness instructor? Obviously, it's things like providing safe cueing, right? Making sure that we are walking our participants through exercises and demonstrating them appropriately and cueing them in an appropriate manner so they perform them appropriately. The judge will then look at the failure was the proximate cause of injury. So did the group fitness instructor failed? Number 1, did they fail to perform that standard of care? And number 3, would that failure lead to the actual injury that occurred? And then number 4, did actual damages occur? Did the plaintiff, the person filing the lawsuit, become injured? So in a court of law, a judge is going to look at those 4 different legal elements in order to substantiate a claim of negligence. So another quick thinking it through. So how much time do you spend thinking about the law and its impact upon your career as a group fitness instructor? And what legal or specific legal related questions do you have that pertain to your profession? Take a minute, think about that. What legal related questions might you have related to maybe a group fitness instructor or even a personal trainer? Although each group fitness instructor will have unique questions related to their profession based on experience, group fitness instructors should have a firm grasp on the legal concepts provided in this chapter, as they relate directly to working in the fitness field. If there are areas where you have unanswered questions, make an effort to speak with an attorney or appropriate professional related to your concerns before you begin working as a group fitness instructor. So if you have, it's always nice if you have a family member or a close friend that's an attorney that you can maybe ask those types of questions of, and even have them take a look at any legal documents that you might be having participants fill out or sign, like waivers and informed consents and things like that. It's always nice to have that other set of eyes on things like that and have that person that you can answer those or ask those types of questions. So the duties assigned to health and exercise professionals vary from one position to another and from one organization to another organization. So each area of responsibility poses unique questions that are important to every certified instructor. So ACE's Code of Ethics, which is presented in your Appendix A of your book, is helpful in guiding the actions of health and exercise professionals. So our areas of responsibility are providing health screening, especially if you're that independent contractor. We want to make sure that prior to exercise, we're screening our participants appropriately so we know if they have any health-related issues that might warrant them to get a referral from a physician before starting exercise with us. And then instruction, we want to make sure that our instruction is sufficient. We're giving the right types of cueing, and it's understandable to the participants. And again, it's going to conform to that standard of care. Other areas of responsibility for group fitness instructors is the supervision area. So we want to make sure that we supervise in immediate proximity to our classes, to our participants in our classes. Only allow a class to be large enough to be competently monitored, but we don't want to be too large where we can't really monitor every single person in the class. So having everybody in full view of the group fitness instructor is a good question. Do you have that when you're teaching a class? You want to have full view of everyone. And specific supervision employed when activity merits close attention. So maybe if you're doing, some high intensity intervals, or you're doing some different types of weight training movements that require very specific form, we want to have specific, one-on-one supervision, or, a smaller group supervision, because of those types of activities might require a lot more close supervision, or be closely supervised, I should say. And then, of course, our other area of responsibility is the facilities and the equipment that we're using. If you look at page 237 in your textbook, actually it does list a lot of great ideas for guidelines as far as making sure the facility is properly equipped, and then the equipment is ready to go as well. As far as the risk management, how do we reduce the risk of maybe getting sued or becoming negligent or being held liable? Well, there are risks to any activity. I have to say that up front. But exercise programs carry certain special risks due to the physical movement and exertion often required. Group fitness instructors should constantly search for methods to make the environment safer for their participants, periodically reviewing the program, the facility, the equipment, to evaluate the potential dangers allows the group fitness instructor to decide the best way to minimize potentially costly injuries. Furthermore, appropriately implementing waivers, informed consent, and agreements to participate will help reduce our overall risk. So again, a waiver, what is it? It's going to release the instructor and the fitness center from all liability associated with the conduct of an exercise program and any resulting injuries. So waivers are key. And also informed consents are another great form to have implemented. That's used to make the dangers of a program or test procedure known to the participant. So up front, they're letting the participant know there are dangers associated with exercise. I always tell people, but the benefits of exercise far outweigh the risks. But it's just a legal document that we have to produce, and just let them know up front there's always a risk for injury when you exercise in any case. Agreement to participate. If you look in your textbook, there's actually a sample on page 239 of this, but this is designed to protect the group fitness instructor from a participant claiming to be unaware of the potential risks of physical activity. So that agreement to participate, again, says that we have let our participants know up front the dangers and the risks associated with this program. So it should detail things like the nature of the activity that you're doing. Okay, what types of exercises will you be performing? The potential risks that could come along with performing those types of exercises. And then, of course, the expected behaviors of the participants. So before beginning the first session of a 6-week boot camp series, you ask new participants to complete a health history form and sign a liability waiver. One participant says that she does not want to sign any paperwork before trying out the class and is very excited to just get started. What potential issues might arise if you do not require the participant to sign the waiver? What do you think? Take a minute and think about that. It is crucial for all group fitness participants to complete a health history form, an informed consent form, and a liability waiver. Those three are of utmost importance. They protect the group fitness instructor from potential negligence and from performing services outside of their scope of practice. And they protect the participants as well from undertaking activities that they may not be prepared to tolerate, which could cause injury or even death. So again, going back to that agreement to participate and that informed consent, when they read it through, they can understand, oh, okay, these are the types of exercises that I'm going to be doing in this particular class. And then they can make that decision if it's appropriate for them or not. Insurance. if we are an independent contractor, it's definitely important to secure some professional liability insurance. Professional liability insurance should cover any personal injuries that occur as a result of an exercise session, um, but and also it can cover participants in our classes who might become injured. They might sue for things like medical expenses. They might sue for lost wages from being unable to go to work, and even the pain and suffering. So as far as, that professional liability insurance, it's going to cover, not only personal injuries that occur during the exercise session, but if our participants get injured during the session, any damages that they might sue for, that professional insurance would cover that as well. So that's a big, big type of insurance that independent contractors especially should try to look into purchasing. Also, acute injuries need to be handled quickly but with caution. So as participant safety is paramount. So a group fitness instructor should apply the first aid and emergency response actions learned from their primary emergency training and refer the participant to an appropriate healthcare provider when an injury is serious. So also other contracts that we can put into place. If we're going to have a participant sign a contract, the 4 things that need to be on the contract is an offer and an acceptance. So there's a mutual agreement of the terms, okay, an offer and an acceptance. So there's a mutual agreement. Consideration is an exchange of items of value. We're exchanging items of value. I'm allowing you to participate in X amount of group fitness classes, and you are paying me, X amount of dollars for doing that. That's exchanging items of value. Legality, it's an acceptable form and subject under law. And then capacity, such as, majority of age and mental competency are things to look at under capacity. And then, of course, looking at employment status, you have different employment statuses like employees versus independent contractors. And if you look on page 242, actually, in your textbook, it does discuss the differences between, when is a person seen as an employee versus when is an person seen as an independent contractor. And there's pros and cons to both of those, right? So there's a lot of pros and a lot of cons that can go with each one. So there are actually court-determined tests or questions that a judge would look at to determine, what that person's status is. But if you look at page 242, also I have a great video that does talk a lot about the importance or the differences between employees and independent contractors. Other legal considerations is copyright law. So a group fitness instructor who uses a playlist of different downloaded songs and uses it in a for-profit class could be in violation of this copyright law. So if we are downloading songs, say from, your iTunes account, you are paying for those songs. Okay, so you'll be able to use those in your classes. So when you download a song, you pay for it, you can use those types of things. But if not, if you're just copying a song without paying for it, then you're going to be held liable, possibly. So it's hard to police, but that is, a form of copyright law. So it's always good to use copyrighted music in our group fitness classes. And we already talked about back in, I think it was chapter 4, power music and the click mix thing that they have on their website, and how we can download different music from power music, and that's all copyright music. So that would all be safe to use. And then trademarks, we have to be careful to use names of certain classes unless we have completed that type of training. So for example, we can't label a class as Zumba if we haven't went through the Zumba training and become an actual formal Zumba instructor, right? So we have to be careful about the trademark names. A lot of those trademark names, you have to go through their specialty training and get their specialty certification to be able to use the title, that type of title, in your class when you're teaching it. So something to think about. Other legal considerations, shared use space. So research the jurisdiction of the potential workout area. So obviously parks are a big thing today that people use as a shared space. But first of all, you want to make sure that you're talking to the township or the city or whoever is in charge of that particular park to make sure that it's okay for you to use that particular piece of property. There might be a fee associated with it. There might be paperwork associated with using that particular area. You might, have to fill out some different documents. So you just want to make sure that as far as the shared space, those types of workout areas, you want to talk to the right people to make sure that it's okay for you to use that particular space. And then ADA, Americans with Disabilities, prohibits the discrimination on the basis of disability. So again, if we're utilizing a space, making sure that it is ADA compliant. It just should be ADA compliant, right? Light switches should be lower for those folks in a wheelchair. Is there a ramp that it's accessible to folks who, might have to use a wheelchair to get in? Just making sure the ADA side of it is taken care of. And then participant confidentiality, as I talked about before, you are gathering personal health information. So we can't divulge and share that information with other people, and even if a friend or a family member of, that particular person asks you how they're doing in your class, you really shouldn't divulge any information because it's personal information. So we want to keep that, their information confidential. So the ACE professional practices and disciplinary procedures are intended to inform ACE certified professionals, the candidates for the ACE certification, and the public about the ACE application and certification standards relative to professional conduct and disciplinary procedures. ACE may revoke or otherwise take action with regard to the application or certification of an individual in the case of violation of these practices. So thus the ACE certified group fitness instructor should have a good understanding of these concepts. So basically they're saying if we do act fraudulently or negligently, or we are found liable, ACE does have the right to revoke our certification. So we just want to make sure we're staying within our scope of practice. We're doing everything on the up and up as far as the group fitness goes, and we shouldn't have to worry about anything of that nature. So given the nature of physical activity and the continual evolution of legal standards, what will you do to remain up to date regarding the legal requirements of your profession? What resources can you utilize to not only maintain but enhance your understanding of the law and its impact on the fitness industry? To remain up to date on the legal requirements related to being a fitness professional, the group fitness instructor should regularly review any new recommendations and guidelines provided by industry organizations, such as International Health, Racquet, and Sports Club Association, the American Heart Association, the American College of Sports Medicine. Those are all industry organizations that would have these types of guidelines, as well as rely on the counsel of an attorney who understands the unique need for his or her practice regarding state and federal regulations.